the second episode of Risk Settlement's podcast, Alternative Litigation Strategies, which features interviews with key leaders in the commercial litigation industry. Our guests discuss novel litigation and settlement strategies for complex litigation, including class action litigation. I'm your host, Kevin Skrzowski, a national director at Risk Settlements, and today we'll be discussing the impact of the Supreme Court's Facebook decision and resulting trends in TCPA litigation and settlements. I'm honored to be joined today by Richik Sarkar, a commercial litigation partner at the law firm Dinsmore & Scholl. Good morning, Richik, and thank you for joining.
It's my honor as well.
Great. So as we all know, on April 1st, the United States Supreme Court made a landmark decision regarding the Telephone Consumer Protection Act, and specifically what constitutes an automated telephone dialing system for the purposes of TCPA. Can you take us through a few key points of that decision?
Sure. Facebook versus DeGuid was a U.S. Supreme Court case related to the definition and function of auto dialers under the Telephone Consumer Protection Act, or the TCPA, to send unsolicited text messages. It was an opinion based on the statutory interpretation of the TCPA, and the Supreme Court ruled that auto dialers are defined by their function to either store or produce telephone numbers from a random or sequential number generator. Now, on its face, it would seem that the Supreme Court basically says the law means what it says. But in fact, there's a lot of history behind this, and some of that kind of is covered by the judicial history of this case. In 2014, Noah DeGuid began receiving text messages on his cell phone from Facebook warning him about suspicious activity on his account, even though he had never set up a Facebook account. So after bringing this up with Facebook and not getting what he considered to be the proper response, he filed a class action against Facebook in the Northern District of California and asserted that Facebook violated the auto dialer statute because the messages that he received were being placed by an automatic telephone dialing system, or what is commonly now known as ATDS. Facebook challenged that claim in the court and said, listen, their messages were targeted to specific phone numbers and not to random or sequentially generated numbers. And the district court judge agreed with them and dismissed the case, ruling that the plaintiff did not establish that an ATDS was being used. However, the Ninth Circuit reversed, and then the Supreme Court accepted the case. And, this is for statutory interpretation aficionados, this is a great opinion because it really goes through a lot of the rules of statutory construction and what you should do and what different things mean in different places. And interestingly, one of the more recognized experts in statutory construction, Brian Garner, argued this case in front of the Supreme Court. And the Supreme Court used a number of these tools, but ultimately found that the dialing system used by Facebook did not qualify as an ATDS, and that only systems that have capacity to either store a telephone number using a random or sequential number generator, or that can produce a telephone number using a random or sequential number generator can qualify as an automatic dialer under the TCPA. This is because Congress's chosen definition of an auto dialer requires that the equipment in question must use a random or sequential number generator. That definition excludes equipment like Facebook's login notification system, which didn't use that technology. The other thing that was at issue here was the fact that it was argued that, this machinery could be used to generate random or sequential numbers. And the Supreme Court basically rejected that this is not a could be, this is a does use. It is using this to do that. And in finding that, Congress found that auto dialer technology was harmful because auto dialers can dial emergency lines randomly or tie up all the sequentially numbered phone lines at a single entity. And Facebook's interpretation of the TCPA, which was what the court found, they thought that was much better in keeping with that purpose of the TCPA than the plaintiff's interpretation, which essentially would have covered any equipment that stores or dial phone numbers. And that would have included, your cell phone, your desk phone, if you have the capacity to store some numbers. And again, they also, they talked about this almost in a text message focused sort of way. They really didn't get too much into the cell phone numbers or cell phone calls. It really focused on the text message aspect of what was going on in Facebook's system. But it did give us a lot of good guidance with regards to what is necessary now for something to qualify as an ATDS. And it's favorable to the telemarketing industry, collection industry, because it narrows the definition of an ATDS And it also, for text messages, kind of reinforces what many people have been arguing, that the TCPA isn't really a text message statute. It wasn't contemplated when they were drafting it in 1991. I mean, it may have existed. I mean, I wasn't in 1991. I did not have a cell phone, so I don't know what capacity one had then. But I think it kind of lends credence to the fact that really text messages aren't things that should be governed by the TCPA. They didn't jump out and say that, but they basically did when they employed this definition of an ATDS, because it really covers everyone that is sending out mass text messages.
So, I mean, clearly it seems to be a victory for certain types of businesses, especially those that use predictive dialers and preview dialers without capability to randomly or sequentially, source numbers or have those source codes. Given this decision, what guidance do you provide your clients, or would you provide a business who use those systems to ensure that they're limiting the possibility of claims moving forward?
Yeah, I tell my clients, first of all, this does not mean that the TCPA is gone and done with. First of all, the way that this opinion is written, it is much more of you still need to bring proof of what your system can and cannot do. Explain to my clients that the best thing that we can do right now is get expert opinions or manufacturer statements that establish that the technology that a particular company is using to contact consumers by phone or text can't store numbers or produce numbers randomly or sequentially. For example, many cloud-based systems can only reach consumers from existing customer files or lists, and they can't just contact customers randomly. Or typically you want to have a set of parameters that set up when and how you're going to call customers. And so if you can get that sort of affidavit or declaration from an expert or a manufacturer of a machine, you can then use that at the very beginning when you get a demand letter or when a complaint is first filed, and show it to opposing counsel and explain to them that you don't have an ATDS and here's the proof. In many cases, you can convince the opposing counsel that they should either drop the case or settle it at a much lower value rate than what they may have originally been demanding.
That's great advice, and I definitely want to touch on settlements a little bit later on in the podcast. Particularly, that's great advice, to mitigate the risk of potential TCPA exposure, in those circumstances where an ATDS is being used. But I have heard about some of the potential pitfalls that were left unresolved by the Supreme Court's decision. Specifically, I've been hearing quite a bit, especially from the plaintiffs bar, about footnote 7 of the decision and leveraging footnote 7 as an avenue towards ATDS claims going forward. What are your thoughts about footnote 7?
Well, footnote 7 essentially introduced by the court a hypothetical that one of the amici had filed an amicus brief as part of this thing had raised as an example of what could happen in a certain situation. And in that example, it talked about how someone could use a random number generator to create an order of calls and then store that order later on. Plaintiffs' counsel seemed to think that might create a source of liability. I don't really agree with that, just because when you look at footnote 7, you need to think about it in the context of the overall argument from which that quote was being pulled from. And I really don't think that it really lends itself to that sort of conclusion that this is where you can find a loophole in the opinion and drive through it. I actually think that when you think about the overall purposes of the statute contemplates the random generation of phone numbers, not the random generation of an order of phone calls. And so it doesn't really go with the overall thrust of the statute, which is to prevent someone from randomly generating, 8675309 and then calling it. That's what the statute was meant to prevent. It was not meant to prevent, someone from having a million phone numbers and saying, I'm going to dial numbers 887, 93, 17, 6. So I really don't think that the hypothetical complies with the thrust of the statute. The other thing I think is that this argument is going to get smushed together with the argument with respect to capacity. Again, some people are saying that, well, if a system could do something, even though it's not being used to do that, it could be violative of the statute. And I really think that I go with Congress's intent, and it says to use. It does not say can use, it says to use. So I think that the fact that you could have a system where it can generate a random list of numbers and then call them doesn't mean that it is. And so again, you'd want a affidavit that would essentially support the fact that that's not something that machine can do. The other thing to think about is that practically speaking, no one would want a randomly generated list of phone numbers from a random order, I should say, for collection purposes or marketing purposes. And that's because the way that this statute and other statutes, do not call statutes and other statutes that deal with contacting people by phone, they restrict the hours within which you can actually make phone calls. So if I had a random list of numbers out of my system, I can't tell what time zone those things are in. So I could be violating the statute, another statute, by placing a phone call in a random order because I need to make sure that, if I'm calling from the Eastern time zone, I'm not violating the statute by calling too early or too late in the Western time zone. On a practical matter, no one would really want that sort of list generation. It is more often the case that, they set up specific parameters within which the system kind of filters out numbers, and that's how that they already have in the system. They don't generate any numbers. They have numbers off of customer lists or other consent lists, and then they use specific parameters to decide in what order to call them. The fact that you're doing all those things means that it's not randomly generated, and it wouldn't be violating the TCPA.
Interesting. I think those are all very excellent points. And so I understand, your arguments as to why there might not be much risk there. I believe the court has allowed some additional briefing onto footnote 7. So it'll be interesting to see how that plays out. And of course, the lawsuits that get filed thinking that there is a loophole in the decision through footnote 7 and the resulting decisions. But, putting that issue aside, and, as you mentioned, neither of us is arguing that the TCPA is dead. It certainly isn't, because it covers much more than just ATDS systems. And since the Facebook decision, we're seeing a lot of TCPA lawsuits that are being filed. What are the current trends that you're seeing, and what do you anticipate in the future regarding claims based on things such as pre-recorded and artificial voice calls to numbers on the DNC, or what are termed as fax blasts?
Yeah, I think that you are going to see a couple of things. One, there's going to be a glut of cases that were being stayed while Facebook was being decided. Those now need to probably be, in many cases, rebriefed and then move through the system. And so we'll get a better idea of things like footnote 7 and how courts are going to deal with that. We'll get a better idea of how they're going to actually employ Facebook. I think that you're going to see TCPA cases are now going to be paired with do not call sort of violations, like you said before. I think also you're going to have they'll focus more on pre-recorded or artificial voice calls. And then you're still going to have junk fax cases, because this doesn't really deal with faxes. But I think the most important thing that you're going to see is that you're going to pair a federal TCPA claim with many of the states have their own, what we call mini TCPA statutes, which, kind of mirror what the TCPA is, but does it under state law. And or they have their own laws covering debt collection or abusive practices. And I think that you're going to see a lot of these cases are now paired with that sort of thing. Before, you would have seen just a standalone TCPA case. Now you're going to see it paired with a lot of other actions, just to kind of create something that you can't just take out of the box with an affidavit, or you'll still need to do some discovery in order to establish or defend against those claims. But I think that you're going to see a lot of those types of actions. TCPA plus now is probably what it will be. It used to be just TCPA by itself, and now it'll probably be paired with other actions going forward.
I think you're right on that. And we're seeing a proliferation in our business, especially with the fax blast. We work with a lot of counsel that represent companies in the healthcare profession. So whether it's medical device or health IT software or pharmaceuticals, and they normally notify their customers about new products or businesses through the fax blasts. And so we're working on a lot of settlements right now where the faxes have been sent en masse to their customers who are healthcare providers. As you mentioned, there definitely is a lot of potential TCPA exposure that businesses can continue to face. And of course, TCPA lawsuits are quite expensive given the statutory penalties of $500 or $1,500 per violation, which can be quite daunting for any size business. And then we recently saw the Seventh Circuit decide in the Mesa Laboratories case that when an insurance policy provides that the insurer has no duty to defend its insured against any claim arising out of the TCPA, that exclusion also extends to common law claims arising from TCPA violating conduct. So since most companies which are defending a TCPA class action lawsuit don't have coverage, what are some of the strategies that you employ to try to limit a business's exposure on the front end or pre-litigation? And I believe you've already touched on a few of these during the discussion. But then what are some other strategies that you employ to negotiate a cost-effective settlement on the back end, meaning during litigation?
I think the best thing that you can do in order to insulate yourself from liability here, since you can't get insurance coverage, is to make it a systematic priority to get prior express consent before making calls or sending texts, and then maintain accurate records about when such consent is obtained and if it is revoked, when it's revoked. Prior express consent is often incorporated into service agreements and credit card agreements. But I think that the more that you can get people to give you permission to call them on these numbers and text them at these numbers, the better off that you will be, because that will be a very good defense later on with respect to a lot of these claims. And again, obtaining expert opinions or manufacturing statements that establish that the technology that you're using does not constitute an ATDS is another good piece of evidence to have at hand when you get one of these claims in. When you use these tools and you have that sort of record that you can show plaintiff's counsel, you can often either convince them not to pursue their action or to settle it much earlier than they would want to at an amount that, that might be lower than what they had originally demanded. We had talked a little bit about junk faxes before. One thing to keep in mind with respect to junk faxes is that the TCPA does not cover faxes that are sent to an online fax service. So, for example, if you're sending a fax to something and they convert it into an email, or it goes from an email to be converted into a fax, the FCC does not consider that to be covered by the TCPA. So in some of these junk fax cases, again, you want to look at the technology to see how it's being used and what it does and where it goes. Because, again, if you can get an affidavit that establishes the process that you're using when you go through this, again, you can use that as a point of defense in those cases.
Definitely. And in terms of settlement structures and settlement strategies, of course, we're in the business of transferring the settlement risk through class action settlement insurance, a novel product which has been on the market now for a few years. What are some of the methods that you employ to negotiate cost-effective settlement structures? And I know you and I have spoken about some of the solutions that we provide in the past as well.
Depending on the type of case and what's going on, I may consult with others about how other cases are typically being settled and what the parameters are that I should be looking at. And so I use a lot of different services, your services, Risk Settlement. You have one of the largest databases of settlements that I know that exists. And so it is a really good tool then to use to kind of gauge where you should be and what you should be thinking about when you're contemplating settlement. And again, I like to, depending on the case, we've had discussions about actions and potential solutions that you could offer. I mean, that's something that we always try to bring up sooner rather than later with the client in order to determine what's the best way to address and resolve these types of claims.
And it ties back into my prior comment about the availability of insurance, because if a company is defending a TCPA litigation, again, traditional insurance policies are unlikely to provide much, if any, coverage. And so you might want to explore an option such as class action settlement insurance, which operates as a risk transfer vehicle. A lot of people who listen, follow us on our podcast, but for those, that don't, class action settlement insurance or CASI can be purchased to transfer the settlement risk in existing class action litigation. And it's not just available for TCPA cases. It's available for other types of statutory cases and other consumer class action cases as well, including fraud, mislabeling, products liability, breach of warranty, false advertising. It's a bespoke policy. There's no deductible or self-insurance requirement, just a one-time premium that transfers all of the aggregate settlement liability. And most of the times when we're working with counsel or their clients, they tell us that they like the certainty and the finality that Cassie provides, that it is a way for them at the proper point or proper inflection point or the right type of litigation at the right time to exit the litigation for a known fixed cost and to avoid the P&L and the balance sheet impairment that would come with a traditional settlement structure. And of course, that helps them avoid some of the opportunity costs of worrying about the litigation as well. Before we go, do you have any final thoughts on TCPA litigation? And what type of programming can we expect from you and your law firm regarding these topics or any other hot areas of commercial litigation?
Yeah, I mean, I think that TCPA litigation is not going to go away. I think what might go away are some of the smaller cases or cases that are being brought by people that aren't really as familiar with the statute, but may think that they can get a quick buck out of it because other people have filed these lawsuits and have gotten settlements. I think we're going to kind of weed out the mere filers from the actual expert practitioners. And I think that some of the cases that do survive are going to be much more fact-intensive and complex and comprehensive. At Dinsmore, we've recently just done a webinar that covered the Facebook opinion that's available on our website. We are always kind of keeping an eye out on key decisions, and either through our LinkedIn page or our website, and our client alerts are always putting things out with respect to those types of cases. And we do the same thing as part of our class action practice. You know, we cover 29 states and we have over 730 attorneys. So we have a pretty comprehensive law firm practice. And in that, we have a very comprehensive class action practice. And we're very focused on consumer facing issues and actually have teams of attorneys that all they do are handle consumer class actions. And we try to report on key decisions as they come out and make information available to our clients and the legal community as quickly and efficiently as possible.
That's great. So, for those of you who listen to this podcast and they would like to listen to Richard and Dinsmore's webinar, which was even a bit more robust and expansive than the conversation that we had today, please be sure to visit their website, which can be found at www.dinsmore.com. Well, Richard, I think that's about all the time that we have for today. It was a pleasure having you as my guest. Thank you for your time and the valuable insights that you shared with our audience today.
It has been my pleasure.
Wonderful. And I would also like to thank the audience for listening. If you'd like to hear more, please be sure to follow us on Apple, Spotify, or anywhere you listen to your favorite podcasts. If you'd like to listen to a recording of today's program or would like to learn more about litigation and settlement risk transfer solutions that are available, including solutions to transfer the settlement risk in active TCPA litigation, please visit the Risk Settlements website at www.risksettlements.com, or you can reach out to me directly at kevins@risksettlements.com. Thank you all for listening, and until next time.